Alyssa Mercante has submitted the plaintiff's memorandum of law in opposition to defendant's motion to dismiss officially, which is the second to last step before the judge makes any kind of judgment on the case. The final thing, as my lawyer Ron Coleman puts it, is we get last licks. We're able to put a rebuttal to their rebuttal at the very end. And then it gets seen by the judge. And this is, I believe, 40 pages, 40 plus pages of talking about why they feel like our motion to dismiss the case should be dismissed in its own right. And I attempted to, it's 31 pages, well, 40 with the table of contents. I attempted to read through this, and it's just a bunch of lies and a mess. And I think a better angle and approach to do would be to head over to ChatGPT. And I sent a question posting the entire case into this. And I said, is this a strong case? Because I'm curious to see what a summary from ChatGPT of all of this would tell me, because I'm not a lawyer, nor a judge, nor do I pretend to be one on YouTube. And they said, thanks for sharing this in-depth filing. Here's a breakdown of how strong this case appears, strictly from a legal standpoint, based on the content provided. Not whether the allegations are true, which is very important because many, if not all of them, are false, but whether they are plausibly pleaded and potentially viable in court, which at the end of the day, that's all they care to get across for this to be heard. So it's almost like they are making up things, fabricating lies, throwing everything at the wall and seeing what sticks, in hopes that the judge will read it and be like, damn, this Smash JT guy sounds awful. We definitely need to hear this case and hear more about this. If they're able to fool the judge with their lies, many lies in the statement that they provided. Strength of the case. Comprehensive and detailed pleading. The second amended complaint is highly detailed and seems crafted to withstand a motion to dismiss. It includes allegations of a long-running campaign, 90 plus videos, 150 plus hours of content, clear examples of alleged harassment, including screenshots of vile threats, which again, were not from me, but ChatGPT can't delineate the two because of how they wrote it. Alleged motivation, targeting someone based on gender, sexuality, and political stance, which, again, really hard to prove that. More things to throw at the wall, but it is what it is. This level of detail is exactly what courts require under Twombly L-Q-Ball standards for plausibility. Number two, strong argument for jurisdiction. Despite you being a California resident, they build two parallel bases for New York jurisdiction. Tortious acts committed out of state causing in-state harm with economic ties, business transacted via Wix, a New York company, and collaboration with New York-based streamers. This is legally clever and potentially persuasive, meaning that they're trying to persuade the judge to hear this based off of what they're alleging. It doesn't necessarily mean it's true or that it would hold up. They just want the judge to not throw it out based off of jurisdiction. So they're grasping at straws. But you never know. You never know. Fault and actual malice argument. They allege you knowingly lied about Mercante being a sex worker, which I didn't. But even if I did, she herself has acknowledged that she was a cam girl, which can qualify as a sex worker, depending on the definition of it. So are we splitting hairs on this? Like what is the argument here? That she's allowed to say it, but I'm not? You falsely cited a tweet made after your statement to justify your claims. So she has many different tweets, but because they're saying I falsely cited a different one when someone said, where'd you hear about that? And it was after the fact, even though there were plenty of others I saw that were before it. I just picked the wrong one when I was like, oh, that's one of them that I saw. You had a motive, view farming, and animus Mercante crazy bitches, etc. Even if she's ruled a limited purpose public figure, they've laid out a roadmap for actual malice, which is a high bar, but not unreachable here. Well, it is unreachable once you actually get to the lack of facts and evidence. They are presenting these as facts and they need to prove them, which I'm quite confident they can't. But ChatGPT doesn't know that. Multiple independent claims. The S79N and prima facie tort claims are not based on defamation. So even if defamation gets tossed, they survive independently. Smart lawyering. Waiver strategy. They argue that you didn't even address certain claims, like stochastic terrorism, directly in your motion, which might allow those claims to survive by default. Ooh. Weaknesses, vulnerabilities of the plaintiff's case. Overreach in narrative. The emotional and politically loaded language, e.g., crazy bitches, culture war obsessed trolls, right-wing audience, might alienate the judge or jury. It feels like a political hit piece at times. At times? Highly debatable damages. The central claim of reputation damage depends on whether the court believes the accusation of past sex work is provably false and damaging. If your statements are viewed as one, opinion, which it is, and or two, based on truthful or public information, which it also is, e.g., if she did say she was a cam girl, it weakens their case. Potential weakness in causation. They rely heavily on third-party harassment to establish emotional distress. Again, what I was saying is they keep saying, I'm the one harassing her. Look at all these other people harassing her. And I'm like, that's not me harassing her. That's everyone else. Why is she suing me? And reputational harm, but must prove you caused it directly or intended it through incitement. That's not easy. It's not easy even if someone does do that. I didn't do that, so it's extremely difficult to do that. First Amendment anti-slap. Although they downplay this, you have First Amendment defenses that may carry weight, especially if this is seen as public commentary on a public figure. Anti-slap protections are still evolving in federal court, but may apply depending on jurisdictional interpretations. Bottom line, is this a strong case? Yes, it's strong enough to survive the motion to dismiss. It's factually detailed, cites relevant precedent, and frames multiple independent causes of action. But it's far from a slam dunk. It hinges on proving falsity, fault, or malice and causation, and it risks alienating the court with emotional and political rhetoric that may not land well, which would explain exactly why they were requesting a jury trial so that they could work on manipulating the emotions of humans to make it feel, play on the empathy of people. Oh, look at her. She's just a girl and she's hurt and sad. Look at her. She's just so broken. Look at all her tattoos and nose rings and everything. And the CUNT thing on the side of her head. Look at that. She doesn't know. She's just a poor little girl in this world. And this evil man over in California is talking about her. And that's really bad. So I do find it interesting that it says it's strong enough to survive the motion to dismiss. And it makes me wonder, because my lawyer, Ron Coleman, is not an idiot. And I would like to think his years of experience going into this, he read through this himself. And I would imagine he probably came to a similar conclusion, which would explain why he came to me saying, this might actually get expensive. I feel good about our chances, but just being honest with you, it might start getting expensive. That was from my lawyer telling me not to expect this to just go away instantly. As much as we'd all love that to happen, unfortunately, it feels like because of the lies, the miles and miles of lies, and yes, I'm exaggerating for a point, but there are many lies after lies after lies, saying that I have streamed with Rev Says Desu, who I've never so much as even chatted with in my life outside of minor Twitter messages publicly. I don't think I've ever DM'd with him, but they're saying that I stream with him. And they only say that because he's in New York and they're trying to establish jurisdiction by saying all these people are in New York. They say Hypnotic is in New York. Hypnotic has gone on the record multiple times saying he's not. They're wrong, which means that they're wrong about Hypnotic being in New York. They're wrong about me associating with what Rev says Death Suit in New York. And I've had Toasty with the Mosty on here twice, ever, maybe 3 times. And I've been on her channel once, ever, maybe. That's hardly an established ritual of recurring, but they try to make it seem like this is something that we coordinate, that we work behind the scenes, that they say that me and nobody have a conversation on Discord going privately to coordinate an attack or something like that. I've never talked directly to nobody on Discord. And if I have, it was very minimal. I barely even use Discord. I don't know what they're even talking about. I use X for all my communications with people. So this is factually wrong with what they're even saying. They're throwing darts at the wall and hoping stuff sticks. And my concern is with this is that the judge is going to read through all this and be like, damn, that sounds really, really bad. We got to hear this. And then they'll cross that bridge when they get there, when this gets to court, to try to deal with all the lies and hopefully win something when it's being heard. Because at the end of the day, Alyssa has activist lawyers that are representing her, and they have an ultimatum that they're trying, in my humble opinion, to get across here, which is the stochastic terrorism thing that's not even a law, that they're trying to get put into law so that they could potentially use that in other cases to further their agenda, being activists, which would explain them taking this case on potentially pro bono, because they could see this as an avenue to get this law passed to help utilize in future cases to make them more money down the road, or to get more laws passed or agendas pushed for activists, or whatever their ultimate end goal intentions are. But at the end of the day, it sounds to me like this is not going anywhere anytime soon. This is going to start potentially getting far more expensive, and we need to be ready to strap in for a potentially long and very expensive road ahead. And that's one of those things that I can't fight this alone, and I need people's help from it. And Alyssa knows this. And if I'm not able to get that help, then this might actually fall apart, and then there's going to be some serious problems when it comes to what happens next. And I really hope it doesn't get to that point, because I'm very concerned about what happens if it does. But we'll cross that bridge when we get there. But just a heads up to all you guys, this is the latest situation of what's happening. And the next steps is Ron Coleman will be drafting up a response to this. And then that is the final thing before the judge makes any kind of ruling on if they're going to move forward with this or not. But at this point, that's all the information I have on it. And until the next update, I will leave this there.